Good afternoon. Welcome to the Long Live Third Parties podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Woodruff versus Herrera, 623 F3D 1103, Court of Appeals, 10th Circuit, 2010. Friends, we got good stuff for you today, so don't go away. Stay. Friends, this is a case that involves another coalition. There are four entities here: the Green Party of New Mexico, the Libertarian Party of New Mexico, the Reform Party of New Mexico, and La Raza Unida. Way to form a coalition. We've never had a case before that involved La Raza Unida, so we'd like to see them on board. Let's find out what happened in this case. The case decision starts in one of the first paragraphs by giving a compliment to the Green Party. It says, quote, "At times the Green Party of New Mexico has been a significant force in New Mexico politics, perhaps determining the outcome of races for major offices such as governor and members of Congress." End quote. What a testament to the value of the Green Party and to third parties. This case centers on the qualifications to vote. The qualifications to run for office. Let's find out what they were. It says, quote, "Daniel Fenton, a New Mexico resident but not a registered voter, seeks to be a candidate for a seat in the United States House of Representatives. He and the Green Party plaintiffs brought suit in the United States District Court for the District of New Mexico against the Secretary of State to challenge several provisions of the New Mexico Election Code. Only two of the claims are relevant to this appeal. One claim, count 2A of the complaint, challenged the constitutionality of the Election Code requirement that a candidate for a political office be a registered voter. The other, raised in count 4 of the complaint, related to petitions for a minor political party or its candidates. It challenged the constitutionality of the election code provisions regarding the personal address to be placed on such petitions by a qualified voter who signs one." End quote. And then it continues, it says, quote, "The district court agreed with plaintiffs regarding the constitutionality of the provisions. It held that it is unconstitutional to require that a person running for the United States representative to be a registered vote. And it held that the election code is inconsistent regarding whether signers of petitions must state their address of residence or their address as registered, and is therefore unconstitutionally vague." End quote. So friends, we like to see when the district court agrees with third-party activists. We love when that happens. Let me ask you about that qualification. Do you agree with the district court and the Green Party that one shouldn't have to be a registered voter to run for office? Usually people who run for office are concerned with politics, so they happen to be a registered voter. They usually vote themselves. So in many cases, it's not going to apply. But in those situations where it does apply, we want the possibility to be open that a person who is not a registered voter can still run for office. So this court here reviews the district court ruling in this case. Also, our friend, Mr. Fenton, wanted to get on the ballot specifically, and he thought he should be placed on it. So it says, quote, "Mr. Fenton contends that he should be placed on the ballot because the election code has no provisions relating to candidates who are not registered voters. And the Green Party contends that it should not have to file petitions to qualify as a minor political party." End quote. It's one thing to overturn the law, which would help people in the future. He also wants to be placed on the ballot in this case so he can do it at that time in 2010. So it's two focuses here. One on the future, and one in the present. We like to see that approach. Unfortunately, the court didn't buy his arguments. They were saying he should have been gathering petitions while this case was pending in the courts. They said everyone else would have done it, he should have. So what do you think? Do you think that is a legitimate burden our friend should have placed on himself? Or what do you think? And ultimately, the court is not finding him persuasive. They say the following, quote, "The judgment of the district court is affirmed," end quote. So this case did not involve the Green Party being recognized as a minor party, nor did it involve our friend being placed on the ballot. Still, we honor the Green Party and we honor Mr. Fenton for fighting. We like to see that. We do like to see what happened in regards to this law, because that's going to help in the future for anyone who wants to run. Way to go, friends. Way to go. Let's see more of this. Long live third parties. Goodbye.